Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The City of Glendale has rejected petitions filed by city residents who are trying to stop a deal approved by the City Council to lease the Phoenix Coyotes arena to a potential buyer of the team. Now, the city claims the petitions were not valid, they were filed late, and the number of signatures was insufficient. Here with more on that is Glendale City Attorney Craig Tindall. It's good to have you here. Thanks for joining us.
Thank you, Ted. It's great to be here.
Before we get to these petitions and another issue regarding petitions, the deal with the Jameson Group looking to buy the Phoenix Coyotes, the lease agreement deal that the City Council passed, has that been signed?
It hasn't been signed yet. People need to remember that this is a deal that involves not just the city and the new arena manager, but the NHL and the team owner. And so that part of the transaction is very complex all by itself and needs to be taken care of by those two parties. So right now they're in the process of focusing on that. So once that gets far down the line and ready to go, then we'll turn back to ours and get ours all signed and finalized and ready to go.
Okay, so that has to happen first before that deal gets signed.
They'll happen basically together, but they don't always move in sync.
Okay, let's talk about the petitions regarding the group trying to overturn the City Council's lease agreement. Why were those petitions refused?
Well, the primary reason is that it was too late. The statute requires that the petitions be turned in 30 days after the legislative act. There's an exception in the statute, but it didn't apply in this case. So the committee who was fostering the petitions turned them in about 3 days late. And then when they turned them in, they didn't have a sufficient amount of signatures. The signatures are calculated for referendums on a particular citywide election, and that would have been our election in 2008. And so calculating using that number, they didn't have a sufficient number of signatures.
Let's talk about the deadline first, because the group is saying that the paperwork was not available until a few days after the City Council's vote, and so it's not fair to say the 30 days starts with the vote as opposed to when the paperwork was available.
Well, and that's the exception that I did mention before. If you come in and ask for, fill out your application for what's called the petition serial number, if it's not available at that point in time, then you do get a grace period until it is available and can be provided. And so when our ordinance was passed, there was a few days while it went through the standard process to be signed. But the political committee that was fostering the petitions had not come in to ask for their serial number. They didn't do that until several days after it was available. So the statute is meant to provide an opportunity for individuals to have a little bit more time if the city hasn't done what it needs to do. When they came in to get their petition serial numbers, the ordinance was available to them, and so the time ran as of the legislative enactment. So
it's up to them to come in and make sure the city is doing what it's supposed to do?
No. What could have happened, because after an ordinance is enacted, then it's routed through several people to get signatures on it. It becomes official and is filed with a clerk. In normal process, that takes 3 or 4 days, and that's what it took in this case. But if they'd come in and asked for a petition serial number, then people could have walked down the hall and gotten signatures right then and made it available to them at that point in time. So it's meant to provide a grace period if when someone comes in to do the complete application process, it's not available. And again, they came in later when it was available to them, so they don't have any grace period.
Back to the number of required signatures.
Right.
Who decides, I think you touched on this, but give us a better explanation here of who decides and what is the determining factor of how many signatures are needed for something like this? And was that communicated to this group?
Well, actually, the Arizona Constitution decides that. And what the Constitution says is that for a referendum, you need 10% of vote. Along with the Constitution, the legislature has passed statutes that implement the process of referendum. And those statutes, for referendum purposes, say that it's the last citywide election. We are a city of districts, so we have one council member, the mayor, who's voted for citywide. So that's our last city election, which would have been when she was last elected, which is 2008. And so the statute says 10% of the votes that occurred in that election determines the number of signatures that's required for the ballot.
Was that something, again, communicated to this group?
When you come in to get a referendum packet, you're given a whole lot of information, including all the statutes and the constitutional provisions and things like that. So it's pretty clear in there. Now there's a bit of difference in another similar type of process that isn't keyed on a citywide election, and so I think that was probably the source of their confusion. But nonetheless, it's pretty clear in statute.
And that information regarding the summary, I know that was a problem as well, as far as what the city saw. The requirements regarding a written summary, those are available and provided as well? That's
actually right on the application process, but the statute is pretty specific too. Is when you fill out an application, you need to provide a summary. A lot of times it's called a 100-word summary because it has a 100-word limitation. And if you don't provide that, then you haven't completed your application package. So that is another problem, and I didn't mention that at first, but you're right, that is another problem.
So how long do they have now to challenge the fact that they can't challenge?
They have 5 days after our letter went out, and our letter went out on Monday. So you count starting with Tuesday and then 5 days from Tuesday.
All right. There's another referendum initiative process going on out there regarding the city sales tax, and this is a big one because this would affect the city services quite a bit. However, those petitions to reverse this sales tax increase, those petitions were denied as well. Why were those refused?
Yes, it's a different process. The initiative is different than a referendum. A referendum is essentially overturning a law that's been passed. A citizen referendum, legislative bodies can refer as well, but a citizen referendum is meant to overturn a law that's been passed. An initiative is to pass a new law. And that's an important distinction. And it's important all the way through the process. And in this case, the initiative was rejected. It was rejected because they had a problem with their application as well. But more importantly, the description, which they did file in this case, and which appears on all petitions right above where the signature lines are. So it's something that's read by each person who signs the petition, and at least it's supposed to be. And it's an important information, and in that respect, it was deficient in two different areas. It was inaccurate and misleading as far as what it was describing that the ballot measure would do.
And who decides it was just misleading?
Well, it's a matter of law. What the description said is that the ballot measure would reverse the tax increase and would require any future increases to be voted on by the voters. I'm paraphrasing. It's not exactly what it says, but that's the essence of it. Ballot initiatives, when they're passed, are prospective only. Our Supreme Court has ruled that in a case, that they only operate in a prospective manner. So they don't operate to reverse matters. And I should add that this is a charter provision. This isn't just addressing our ordinance, but it's addressing our fundamental law. The organic law of the city is our charter, like a constitution is for a state. And so they're attempting to change that by implementing a new requirement, but it wouldn't change existing law. So it would not reverse, as they said in their description, what was already enacted, which would have been the sales tax increase. And it also deals only with levies. And a levy, with respect to our charter provision, a levy is the initial imposition of the tax rate. It's not an adjustment of the tax rate. And so the fact that their 100-word description said that any future increases would be voted on, or would have to be voted on by the voters, is incorrect. So in two respects, their 100-word statement was misleading and inaccurate. And
there was a deadline problem here. And before you go, I'm kind of curious about this because the election's coming up in August, I believe, for this. It would be coming up in August for this. And yet the City Council passed the sales tax increase in June, and you're telling these folks they need this has to be filed 4 months previous. How can you do that 4 months previous when it was passed in June and the election's in August?
Well, Ted, I'm not telling you anything. That's what the Arizona Constitution says. The Constitution says that ballot propositions such as an initiative need to be presented 4 months prior to an election. And as I said, statutes have been passed by the legislature to implement what the constitutional provisions are. And those statutes say for a municipal election that the ballot measure that's being proposed goes on the next ensuing election. And the next ensuing election for the city is the primary on August the 28th. So when they turn in their ballot measures I forget the exact date, but it's clearly, it was in July, so clearly not 4 months prior to our August 24th.
So that sounds like a little bit of a shutdown move then there, huh?
Well, the courts have been clear is that unlike referendums, who have a 30-day period of time, initiatives can be done at any point in time. And so what people or political committees that are fostering an initiative petition, they need to select the appropriate time to submit their petition.
All right. Well, it's good to have you on the show to kind of explain all this. I know it's kind of
Anytime.
deep weeds, but it's good to have you here, and thanks so much for joining us. We appreciate it.
Absolutely. My pleasure.